You studied for months. You memorized every question. You stood in a room with dozens of strangers, raised your right hand, and swore an oath of allegiance to the United States of America. They handed you a certificate. They called you a citizen. Your family cried. You cried. It was the proudest day of your life. And now in 2026, the government wants to take it back. Not because you committed treason, not because you joined a foreign army, not because you renounced your oath, but because somewhere in your naturalization file, maybe a form you filled out 10 years ago, maybe 20 years ago, there might be an answer that does not match what the government now believes to be true. On December 17th, 2025, the New York Times broke a story that sent shockwaves through every immigrant community in America. Internal guidance from the Trump administration directed USCIS to refer 100 to 200 denaturalization cases per month to the Department of Justice, 100 to 200 American citizens every single month to be placed into proceedings to have their citizenship stripped away. NPR confirmed it on December 24th. NBC News expanded on it on February 12, 2026, reporting that the administration is adding staff at 80 USCIS field offices specifically to identify and pursue these cases. The Brennan Center called it unprecedented. Advocates called it a five-alarm fire. Immigration scholars said it represents the most aggressive citizenship revocation program in modern American history. And just 3 days ago, April 13, 2026, NPR reported that naturalizations have collapsed. Fewer immigrants are even applying for citizenship because the fear of denaturalization has made the very act of becoming American feel like painting a target on your back. This is not a hypothetical. This is happening. And today, I'm going to explain exactly who is being targeted, what the legal grounds are, how the process works, and most critically, what you need to do right now to protect the citizenship you earned. Welcome to Global Immigration Updates. I am Sarup. On this channel, I do not tell you what you want to hear. I tell you what you need to hear. If you are a naturalized U.S. citizen, if your parents are, if your spouse is, if anyone in your life went through the naturalization process, this video is not optional. Subscribe, bell icon, share. Let's go. Let me give you the numbers first because the scale of what is happening has no precedent. From 2017 to 2025, the entire 8-year span, including Trump's first term and Biden's full presidency, the total number of denaturalization cases filed by the Department of Justice was approximately 120. That is about 11 to 15 cases per year, 11 per year out of roughly 23 million naturalized citizens living in the United States. Under the new directive, USCIS has been instructed to refer 100 to 200 cases per month. That is a minimum of 1,200 cases per year, a maximum of 2,400. Compare that to the historical average of 11. We are looking at an increase of 10,000 to 20,000%. And in 2025 alone, the DOJ filed 13 denaturalization cases and won 8. So they were already accelerating before the quota was even announced. On March 26, 2026, the Department of Justice announced it had secured the denaturalization of a convicted gun trafficker and a healthcare fraudster and filed a new complaint against an individual who allegedly committed marriage fraud. These cases are being publicized deliberately. The government wants you to know that they are doing this. They want it to be visible. They want it to create fear. And it is working. NPR's April 13th report showed that naturalization applications have dropped dramatically. In October 2025, 169,159 people began the naturalization process. By December, that number had fallen by nearly 50%. Fewer immigrants are applying for citizenship. Fewer are attending their interviews. Fewer are showing up for oath ceremonies. The message is being received. Becoming an American citizen no longer feels safe. NBC reported that the administration is hiring additional staff at 80 USCIS field offices across the country, whose specific job is to review old naturalization files, identify potential inconsistencies, and generate referrals to DOJ. This is not an investigation triggered by a complaint. This is a systematic bureaucratic machine designed to comb through millions of files looking for anything that can be used as grounds for revocation. Now let me explain the legal basis for denaturalization, because if you understand the law, you can protect yourself from it. There are 4 legal grounds under which the U.S. government can seek to revoke your citizenship. Ground 1. Fraud or misrepresentation during the naturalization process. This is the most common ground and the one the administration is most aggressively pursuing. Under 8 U.S.C. 1-1451, if the government can prove that you concealed or willfully misrepresented a material fact during your naturalization process, your citizenship can be revoked. What does material mean? In the landmark 2017 Supreme Court case, Maslanjak v. United States, the court set an important standard. The government cannot revoke your citizenship for just any false statement. The misrepresentation must be material, meaning it must be the kind of fact that if the government had known the truth, could have led to the denial of your application. The lie has to matter. An immaterial falsehood, a wrong date of entry by a few days, a misspelled employer name is not supposed to be enough. But here is the danger. The administration is interpreting material broadly. They are looking at old N-400 applications and asking, did you disclose every arrest, even the ones that were dismissed? Did you accurately describe every trip outside the country? Did you list every organization you belong to? Did you disclose that speeding ticket from 2009? If anything is missing, they are flagging it. Ground 2. Membership in subversive organizations. If you joined a terrorist organization, a totalitarian party, or any group that advocates the violent overthrow of the U.S. government within 5 years after naturalization, the government can pursue revocation. This ground has historically been used sparingly, but the expanded vetting under Operation Paris, which now includes deep social media analysis, makes it far more likely that membership in certain organizations or even online affiliations could be flagged. Ground 3. Refusal to testify before Congress. If within 10 years of naturalization you refuse to testify before a congressional committee investigating your involvement in subversive activities, citizenship can be revoked. This ground is rarely used, but it exists. Ground 4. Dishonorable military discharge. If you obtained citizenship through military service and were subsequently dishonorably discharged, the citizenship granted on that basis can be revoked. Now, critically, post-naturalization criminal activity was historically not a standalone ground for denaturalization. You could be a citizen who committed a crime and face prison, but not lose your citizenship simply because of the conviction. However, the June 2025 DOJ memo represents a significant policy shift. The administration is now arguing that certain criminal conduct after naturalization, particularly if it involves fraud, identity crimes, or terrorism, can be used as evidence that the person lacked good moral character at the time of naturalization, meaning they should never have been approved in the first place. This is a backdoor. They are using post-naturalization behavior to retroactively challenge the original application. And there is another program you need to know about, Operation Janus. This was a DHS initiative that started under Obama and identified approximately 315,000 naturalization cases where fingerprint data was missing or incomplete. Among those, about 1,600 were flagged for review, and 858 were identified as cases where individuals with prior deportation orders had obtained citizenship. The Trump administration has used Operation Janus as a pipeline for denaturalization referrals, and the 80 office expansion directly builds on this infrastructure. Let me walk you through exactly how denaturalization works, step by step, because understanding the process removes the fear of the unknown. Step 1. USCIS identifies a potential case. This could come from a routine file audit, an Operation Janus fingerprint review, a tip from another agency, or the new systematic review being conducted at the 80 expanded field offices. A USCIS officer reviews your original N-400 application, your interview notes, your background check results, and now your social media history. Step 2. USCIS refers the case to the DOJ's Office of Immigration Litigation. This is where the 100 to 200 per month quota applies. USCIS does not strip your citizenship directly. They send the file to DOJ with a recommendation. Step 3. DOJ reviews the referral and decides whether to file a civil lawsuit against you in federal district court. This is a civil case, not a criminal case. The burden of proof is on the government, and the standard is clear, convincing, and unequivocal evidence. This is a high standard, higher than preponderance of the evidence, but lower than beyond a reasonable doubt. The government must prove its case clearly and convincingly. Step 4. You are served with a complaint. You have the right to hire an attorney. You have the right to present evidence. You have the right to a full trial in federal court before a federal judge. This is not an administrative hearing. This is not an immigration judge. This is a United States federal court. Step 5. If the judge rules against you, your citizenship is revoked by court order. Your certificate of naturalization is canceled. You revert to your previous immigration status, which for many people means you become an undocumented immigrant overnight, and from that moment, you are deportable. Step 6. You can appeal. You have the right to appeal to the Federal Circuit Court and potentially to the Supreme Court. Here is the important thing the government does not advertise. Denaturalization is hard to win. The Supreme Court in Maslanjak and earlier in Kungis, United States established that citizenship is a precious right and that the government bears a heavy burden. Historically, the government has won about 60 to 65% of the cases it files, which means 35 to 40% of people who are targeted successfully defend their citizenship. But here is what keeps me up at night. Even if you win, the process itself is devastating. It takes years. It costs tens of thousands of dollars in legal fees. It destroys your peace of mind. It follows you like a shadow. And while it is happening, you live every day knowing that the country you swore loyalty to is trying to prove you do not belong. So who exactly is in the crosshairs? Based on the DOJ filings, the USCIS guidance, and the patterns I have been tracking, here are the profiles most at risk. Profile 1. People who had prior deportation or removal orders before naturalizing. This is the Operation Janus pipeline. If you were ordered removed under a different identity and later obtained citizenship, the government is actively looking for you. There are an estimated 858 known cases in this category, and the expanded fingerprint analysis could uncover more. Profile 2. People who committed marriage fraud. If you obtained a green card through a marriage that the government now believes was not genuine and you subsequently naturalized, your entire immigration history is on the table. The March 2026 DOJ complaint specifically targeted a marriage fraud case. Profile 3. People who failed to disclose criminal history on their N-400. Even minor offenses, arrests that were dropped, charges that were dismissed, incidents that you genuinely forgot about, can be used as grounds if the government argues you lacked good moral character or made a material misrepresentation. And with social media screening now standard, information that was invisible 20 years ago is now searchable. Profile 4. People who obtain citizenship through fraudulent documents. Fake degrees, forged employment letters, fabricated financial records. If any document in your original file turns out to be fraudulent, the government has strong grounds. Profile 5, and this is the new frontier, people who committed serious crimes after naturalization. Under the expanded DOJ memo from June 2025, the government is exploring whether post-naturalization criminal activity can be used to retroactively challenge the original application. This is legally untested in most circuits, but the administration is pushing it. And then there is the chilling effect profile, the people who are not being targeted, but who are terrified anyway. Naturalization applications have dropped by nearly 50%. Green card holders who are eligible for citizenship are choosing not to apply because they are afraid that the act of applying will draw scrutiny to their files. The very idea of becoming American has been weaponized. Here is what you need to do. Whether you have been a citizen for 1 year or 30 years, this protection plan applies to you. Step 1. Pull your complete naturalization file. File a FOIA request using Form G639 at USCIS.gov. Request every document in your A file, your N400 application, your interview notes, your background check results, your biometric records. You need to see exactly what the government has before they use it against you. Step 2. Review your N400 with an experienced immigration attorney. Go through every answer line by line. Were there any arrests, citations, or interactions with law enforcement that you did not disclose? Were there any trips abroad that you did not list? Were there any organizational memberships you forgot? If there are errors, your attorney can advise you on whether a proactive correction is advisable. Step 3. Gather and preserve evidence of your good moral character. Tax returns, employment records, community involvement, letters from employers and neighbors, church or mosque attendance records, volunteer work documentation. If the government ever challenges your naturalization, the strongest defense is an overwhelming record of who you have been as a citizen. Step 4. Audit your social media and digital footprint. USCIS now reviews social media under Operation Paris and the expanded vetting framework. Go through your accounts. Remove anything that could be misinterpreted. Political posts, group memberships, comments on sensitive topics. This is not about censoring yourself. It is about understanding that anything online can become part of your file. Step 5. Do not panic. I need you to hear this clearly. Denaturalization remains legally difficult for the government. The burden of proof is high. You have the right to a federal trial. The Supreme Court has ruled that citizenship cannot be revoked for immaterial falsehoods. The vast majority of naturalized citizens have absolutely nothing to worry about. But preparation is not panic. Preparation is power. The difference between the person who loses their citizenship and the person who keeps it is almost always preparation. Step 6. If you receive any communication from USCIS or DOJ regarding your naturalization, do not respond without an attorney. Do not attend any interview, sign any document, or answer any question without legal representation. The stakes are too high to face this alone. I want to leave you with something that goes beyond the law. 23 million people in the United States are naturalized citizens. They are doctors, teachers, engineers, small business owners, soldiers, first responders. They are mothers who wake up at 5 in the morning to get their children ready for school. They are fathers who work 2 jobs so their family can have a better life. They are grandparents who left everything they knew, their language, their culture, their home, because they believed in the promise of this country. That promise was never supposed to come with an expiration date. The oath of allegiance does not say you are a citizen until we change our minds. It says, I hereby declare on oath that I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state, or sovereignty. You gave up everything. You committed fully, and that commitment deserves to be honored. If you are a naturalized citizen watching this, you are an American. Your certificate is real. Your oath was real. Your right to be here is protected by the Constitution, by the Supreme Court, and by the highest standards of evidence in civil law. Do not let fear make you forget that. But also, do not let comfort make you unprepared. Share this video with every naturalized citizen you know. Send it to your parents who became citizens in the 90s. Send it to your colleague who just took the oath last year. Send it to the WhatsApp group, to the family chat, to everyone who needs to hear this before they hear it from the wrong source. Drop a comment below. When did you become a citizen? And what is your biggest concern right now? Your story might become my next video. Subscribe, hit the bell, join our WhatsApp alerts. The link is in the description and the pinned comment. Protect your citizenship, protect your family, and never ever sign anything without your attorney.